This is civil and remedial, and drunk driving is a horrible problem.
Well, first off, the Fourth Amendment came out of civil actions. The Fourth Amendment was created very much by the colonists, and their reason, the fact that they were upset with the British using the writs of assistance against them and going in, stopping their horse and buggy, coming into their homes, and looking for customs violations, trying to collect tax. It was a civil remedy that the Fourth Amendment was designed to protect. And that was to protect the intrusion into people's homes and their privacy for the collection of this tax. So I think it becomes a little far afield when we always want to talk about the fact that just now it should only apply in criminal cases. And further, the Court of Appeals in Miggs specifically found that the exclusionary rule should apply to driver's license hearings. That case was somewhat misstated by counsel. In that case, the officer hadn't given the proper warnings under 8-1001. What had happened in Miggs is that the law had just changed. The officer gave oral and written notice under 8-1001 that they could lose their license up to 180 days. That law had just changed 16 days before, and it changed to a year. So they weren't given the proper notices in that case. And they said that there has to be a remedy, there has to be a cure, because otherwise there'd be no reason to have the mandated warnings that are required under 8-1001. So they applied the exclusionary rule in that case. And Your Honor,
here we don't have a statute that says that they have to have reasonable articulable suspicion. I mean, this is at least distinguishable on the basis that Miggs, however you pronounce it, involved a statutory rule that was clearly violated. Something that was a part of the statute having to do with license revocation or suspension. Is that a distinction without a difference in your mind? And if so, why?
Well, Your Honor, the legislature cannot create statutes that are unconstitutional. Roving patrols and stopping of motorists randomly without reasonable articulable suspicion has been said to be violative of the Constitution. It's in Burgoni Points, in Delaware v. Prowse, other Border Patrol cases, and cited repeatedly in a variety of state cases by this court in State v. Deskins. So, first off, it's violative of the Constitution.
Constitution trumps.
Yes. Secondly, the due process. There's no question that a driver's license, like a law license or a medical license, has a property interest, and therefore due process applies.
But you're not making a due process argument, are you? You're making a Fourth Amendment argument.
Well, as well as due process, Your Honor. The due process would apply in this case because we know due process applies to a driver's license hearing. But the question is, what process is due? Well, surely to say that the reason and the initiation, the beginning of the stop that caused the person to have this series of events occur that could lead up to their license being suspended is something that should surely be allowed to be argued.
But, counsel, what's your best due process case then that would help you in this driver's license proceeding?
As far as the due process, Your Honor?
Yes.
I would say Meehan versus Kansas Department of Revenue, Your Honor. They recognize that due process entitles the licensee to certain rights to present evidence during a quasi-judicial revocation hearing.
And how were you denied that right? I mean, the procedure's there for the evidence to be presented, right?
But they're saying we can't argue that. They're saying that the argument as the reason for the stop cannot be argued at a driver's license hearing. So
at the administrative portion?
At the administrative level, at the district court level, at any level, that because 8-1020 specifically delineates the arguments that can be made according to the state, the basis of the stop is not something that can be raised. And that's what the Court of Appeals, unfortunately, found in this case as well. To say that you cannot argue that is one of the more fundamental forms of due process. That's the beginning of the whole case. To eliminate that valid defense to licensees to argue that their Fourth Amendment rights were violated would not provide adequate due process under the 14th Amendment. And finally, Your Honor, the statute in and of itself implicitly implies.
Let me back you up for just 1 second. Make a mental note. You'll go back to that point. But I want to talk just a little more globally about administrative hearings and capacity of the tribunal to decide constitutional questions. These are not the only administrative proceedings where we say, administrative body, you're not the constitutional question caller. The court is. So how does that affect your argument?
Well, I guess when you're talking about the Fourth Amendment and the fact that other constitutional rights have been found to apply to driver's license hearings, and we found that due process does apply. It's not written in 81020. It doesn't say you get this. We found that the exclusionary rule applies. The Court of Appeals did in Miggs to say that an exclusionary rule is a judicially crafted remedy to deter police misconduct arising from Fourth Amendment violations. So if Miggs said the exclusionary rule applies and it's carved out of the Fourth Amendment, again, it would be implicitly implied that the Fourth Amendment should be something that should be able to be argued at a driver's license hearing. We're not saying that they're the deciders of the Constitution, but we're saying that constitutional principles have to apply in certain categories. And due process and notice have been already decided by this court that they do apply. Your Honor, when you're referring again to the statute, the statute implicitly implies that the stop of a vehicle may be raised. Otherwise, the requirement that the officer have the person under arrest would be meaningless. You cannot have a valid arrest based upon probable cause if the stop which preceded it was in fact illegal, because it would be tainted throughout under the fruit of the poisonous tree. And so you cannot have a valid arrest and probable cause based upon that arrest, which is clearly an argument that can be raised at a driver's license hearing, because it's stated explicitly within the statute under 81020 that the person must be in custody or otherwise arrested or involved in a vehicle accident, and so on and so forth. Plus, probable cause for the arrest or probable cause to believe that the person has been operating a vehicle while under the influence of alcohol is also required. And it's the first part of the statute. And in Angle versus Kansas Department of Revenue, they talked about the fact that reasonable grounds is synonymous with probable cause. And the reason is because in Schoenberg versus California, we found you must have probable cause in order to take a blood sample from an individual. So we have to have the probable cause there. Well, it begs the question then, how can you get to this point if the stop which began this whole process was illegal? This court in State v. Deskins said specifically, we do not condone blanket, arbitrary exercises of power by governmental authorities which violate the Fourth Amendment. That's what we have here. This is the roving patrols. This is giving unfettered discretion, unbridled discretion to the officers in the field to pull over whoever they want for whatever they want. And they say, the state wants to argue, well, the officers won't be deterred because they're already going to lose the DUI, or that the evidence would be suppressed. But that's not what the Court of Appeals found in Miggs. They thought it necessary to apply the exclusionary rule knowing that it was going to be applied in the criminal case as well as to the driver's license hearing. And they believed that to be so because otherwise it would render meaningless the requirement of giving those warnings. And it's the same here with the statute. It would be meaningless to require a valid arrest if the stop which preceded cannot be raised and argued at the driver's license hearing. Again, in Prowse, the court held that persons in automobiles on public roadways may not, for that reason alone, have their privacy interfered with at the unbridled discretion of police officers. The Court of Appeals in Miggs also referred to officers taking advantage of their failure to deliver mandated warnings. The state would have officers benefiting from their illegal stops by upholding the suspension of that individual's driver's license. An officer may decide, well, I'll pull the person over, maybe I'll get lucky. And if I don't, if I lose the DUI, oh well, at least maybe their license will get suspended. And maybe that'll keep that person off the road for a while. And if that doesn't happen, at least, if I catch him driving while suspended, then I can arrest him for that, and that has penalties and fines and jail time that are associated with the driving while suspended. And so it gives the discretion to the officer in the field to decide who he's going to pull over, when, and for whatever reason.
Counsel, what about your opponent's position that your client in a situation like that can always seek relief in federal court for violation of his or her civil rights?
I guess, but as he said, how often do they prevail? And I don't know. I don't do civil rights cases. What I can tell you is that what real redress is that for an individual to say, well, okay, I can go, my rights have been violated, the courts of Kansas have decided my rights can be violated in this area, but I'm going to go ahead and go to the federal courts and try to get redress and try to get some monetary relief for my rights being violated. I mean, I don't see how the argument would prevail if this court says you can be pulled over for any reason and that's okay under our complied consent laws, because you're agreeing to get a license says that you've agreed to be pulled over for any reason. And so there is no violation of your civil rights. The Court of Appeals in Miggs stated judicial interpretation of statutes must be reasonable and sensible to effectuate legislative design and the intent of the legislature. Words in a statute should not be given a meaning which leads to uncertainty or confusion if it is possible to construe it otherwise. Certainly by reading this statute to say that it allows officers to stop whoever they want, whenever they want, for whatever reason they want, and that issue cannot be raised and argued at a driver's license hearing would not be sensible, not be reasonable to be stated under the statute. I know the state has cited a variety of sister state cases citing that other states have found that it's okay not to be able to argue. But I don't think we have to look to sister states. I think the Kansas courts have already decided this issue. And they've decided it through Miggs by allowing the exclusionary rule to apply. They've found it through Meehan, which says due process applies. They found it through State v. Deskins, which says we're not allowing roving patrols, that there has to be roadblocks, there has to be discretion